I listened very carefully to the governor at his State of the State message, and I thought I heard him say, and maybe I'm mistaken because you said I'm getting older, my hearing may be getting bad, but I thought the governor said that he was asking for not an independent monitor, but passage of the Keith Wright bill to make permanent a grand jury, a special prosecutor in the Attorney General's office to prosecute these cases and investigate whether or not an additional prosecution is necessary.
I was sitting much farther back than you were, so I might not have heard right either, but my comments are based on the language of the Article 7 bill that was submitted. And I believe what I've just indicated in my comments is consistent with the language that's in that Article 7 bill.
Okay. You're at 0 now. I'm at 0, so I'll turn my time over to the next speaker.
Thank you.
Thank you very much.
Our next speaker is Senator Mike Mazzolio.
Thank you very much.
Good afternoon.
Mr.
Too many people here.
DCS Commissioner, former District Attorney, and a good friend. How are you, Mike?
Good, thank you.
Senator Funke and Senator Askar are going to be talking about other issues regarding parole, but I want to put you on notice in this forum that we are very concerned those of us in the Senate as we review the budget, in terms of the allocation of resources for parole. I know that's not directly within your purview, but certainly we will be probing that with Acting Commissioner Annucci and others. But I wanted you to know that that's a big concern of ours, and particularly in Western New York. The supervision and the problems we've had with the caseload of parole officers, as well as the results of very tragic incidents occurring in your hometown over the last few years regarding those who were out on parole and committing very violent crimes soon after their discharge. So putting you on notice that, Mike. Again, in your region, but we're finding this happening throughout the state, is the scourge of heroin. It's a scourge. It's a deeply rooted problem that is no longer isolated in the inner cities, but expanding well into the suburbs and rural areas. Just as an aside, the sheriff of Seneca County had a forum late last fall, and it was discussed how those traveling from the Central Finger Lakes, going to Rochester and Syracuse to buy their supplies and then come home, a round trip of 80 to 100 miles, and actually distributing as dealers of heroin and having a market in the Central Finger Lakes, which never existed before. But you travel the Thruway, we travel the Thruway. Just think of those who are high on heroin, going back and forth to their places of obtaining supplies and being high on the road, in fact, inebriated under the influence, and it just is nonetheless a very disturbing situation. What is DCJS doing, your agency, to stem the heroin epidemic, to address the heroin epidemic in our state?
That's a very good question. And I certainly agree with you that heroin is a very serious problem. One thing I'd say to preface my remarks, as you noted, I was a prosecutor. I spent 25 years in the DA's office. The last 8 years as the DA, and I can't tell you how many wiretap applications I signed on drug cases, how many search warrants, how many thousands of drug dealers were prosecuted, and God knows how many pounds of heroin and coke and whatever else, and none of it made the drug problem go away. So, when we think about this problem, I think we need to think about it from more than just a law enforcement perspective. If all we do is figure out how to arrest people and how to confiscate drugs, we're on a never-ending treadmill, and we'll just keep doing that with no change. So, a huge part of the equation has to be on the treatment side. And I, in my remarks, briefly talked about how we are bringing evidence-based practices to the support of the funding that we do to make sure that the money that we provide to alternative to incarceration programs, so when people come into the criminal justice system, need help and get referred to help, the help that they're getting is effective help that's done by agencies that are running in a way that is designed to make sure that they get effective treatment and don't keep cycling through the system. So that's one area that we're working in. We've also been very active in terms of naloxone, working with a number of other state agencies. We've been engaged in a program for about 2 years now to train and provide law enforcement officers across the state with naloxone. So far, over 8,000 officers have been trained as part of that program, including about 2,500 trainers under a train-the-trainer model. They've administered naloxone about 1,000 times. Over 900 of those 1,000 administrations have resulted in saves. In addition, we've provided funding and do provide funding to the Special Narcotics Prosecutor, to district attorneys' offices across the state, some of which is used for the prosecution of drug cases. And then through our work with crime analysis centers, we provide resources to local law enforcement on the crime analysis side to help fight this. So those are some of our efforts. Be happy if you want to follow up.
Is there any area of the state that is doing better, that is establishing better successes than maybe other areas of the state?
I travel the entire state, from the North Country to Buffalo to Long Island and everywhere in between, and I consistently hear that this is an issue. I couldn't point to one area and say they've got it figured out.
Well, please, there are many in our conference and all across the legislature. They're deeply concerned about this issue, and your suggestions and guidance in the future will be very helpful as we try to appropriately provide legislative solutions. And I must say the task force that a number of members have served on, the heroin task force, has not just relied on the traditional law enforcement measures. We agree with you that treatment is paramount to ever finalizing and reducing the demand.
I certainly share your concern, appreciate it, and would look forward to working with you on this very important issue. And also wanted to thank you for your service as a senator, too.
Thank you, Madam Chair.
Thank you, Senator. The Assembly?
Assemblyman Graft.
Thank you, Denny. You can leave off the T, though.
I'll pick it up if I find it.
Okay. A few questions. Going back to the police vests. Now, the report that I read was that, we had money allocated to upgrade vests for police officers. And the governor didn't get his whole package. And he basically took his ball and went home. And he gave the money to the DOT. That's the report that I had, right? So I don't know if the plows need Kevlar, that the snowmen are shooting at them, but I don't appreciate the governor sitting there and playing politics with the lives of hardworking police officers. And now I look at this reform package that the governor has, and he's just jumping on the anti-cop bandwagon again. As far as special counsel, now, the grand jury proceedings have been secret, and there's a reason that they're secret for, from the inception. And I'm reading through this stuff, and if I'm not mistaken, and you can correct me if I'm wrong, most of this stuff here says they're allowing the DA to turn over a report if they don't indict. Is that correct? It allows
Part of
them
the
to
provision would allow the district attorney to either do a report or write a letter to make information available to the public explaining why the case resulted the way it did. And I can tell you, I, first of all, spent my entire career trying to support law enforcement, and I strongly disagree with your characterization. But secondly, I personally have been in a position where I have presented high-profile cases to the grand jury where police shot somebody and shot and killed somebody in circumstances, and I felt like my hands were unduly tied in those circumstances where I had to go out and tell the public, this is what happened, and by law, I'm not allowed to tell you one additional word. Not, I don't think anyone wants to disclose names of witnesses that testified or other information that would compromise anybody, but to give the public just a basic level of information so that there can be some understanding. If a case gets no-billed and the determination was that a police officer was justified in doing what he or she did, then I think it's only fair not only to the public but to the police officer that the community have some understanding of why that happened so that they don't have this notion in their head that there was some kind of fix that happened and it was a bad result.
Well, you know, we have duly elected DAs, and that's their job to make this decision, whether they're going to indict or not. And this just looks to me as to, for political purposes, all right, to be able to get another bite at the apple when it comes to police officers.
Actually, it does not. This does not give anybody another bite at the apple. This does not in any way, shape, or form change the law. Right now, under existing law, if a case goes to grand jury and a grand jury no bills, there's a provision in the law that allows the district attorney or any other prosecutor who's duly appointed to go to a judge in that jurisdiction and seek permission to get that case represented to a grand jury based on either new evidence or some flaw with the prior proceeding.
But you're removing that.
That same rule would continue to apply. There is no new bite at the apple. This simply goes to who it is that will be carrying out that function. Will it be the district attorney or will it be a special prosecutor? But it does not create a second bite.
Wait a minute. Now, if the special prosecutor does not like the way that the DA presented the case to the grand jury, right, the special prosecutor can bring the case again, correct?
No.
That's the way I read it.
First of all, does not like is not the standard in the bill. There has to be a substantial flaw with what happened or there has to be new evidence. And secondly, the law right now requires anybody who wants to go back into a grand jury after there's been a no bill to get permission from a judge. And under this proposal, it simply says that there would be a special prosecutor, not the DA, but it does nothing to change that existing section of law. And that special prosecutor would still have to go back in front of a judge and show the judge that there was cause under the existing standard to go back into grand jury before he or she could do so.
Okay. And so the way I'm reading this, and a lot of this is allows the DA may, correct? He doesn't have to give a statement. He doesn't have to write a letter.
Correct.
He doesn't have to go out there.
But if the DA, like me in the situation I was in, felt that it's important that the public understand at a basic level what happened, it gives them the ability to do that.
Okay. Now, is part of this the video cameras for the police officers too? Is that what he's looking at with the ones that they wear?
Yes, that is one of the items that the governor has put forward, not as a budget bill, but in his State of the State or Build to Lead agenda book. And it, frankly, my recollection is that 2 years ago in his State of the State, it was something he talked about. I know there's legislation last year that both the District Attorneys Association and the Innocence Project had signed off on that I believe passed the Senate. And that same framework is the framework that the governor is proposing. We're the only state in the country that doesn't allow photo array identifications into evidence at trial. And all of the research on this issue suggests that if it's done properly, your best identification is the one that's done first and soonest in time to the crime, which almost always is a photo array identification, and yet we keep that best identification from the jury. So that was half of the package. The other half of the package is video recording of interrogations in serious cases. And again, the MPTC has adopted policies regarding it. Almost every major police department in the state is recording, You know, I can tell you as someone who tried cases, the last case I tried was a case where 2 police officers were shot, and one of my best pieces of evidence was 3.5 hours of a recorded interview with the person who was convicted of attempting to murder those police officers. You know, it's something that, you know, I think almost everyone who's up on these issues in law enforcement agrees we should be doing.
Yeah, I'm talking about the body cams. Is that part
All
of
right,
the governor's proposals?
No, I don't believe there's legislation with regard to body cameras.
Okay. Thank you.
Thank you. Senator Squadron.
Thank you very much. Got a lot to cover here. I don't know if you were here earlier when we had an extensive conversation about speedy trial or the absolute lack of speedy trials in New York State.
I was listening to all of it.
I appreciate that. What, if any, data does DCJS keep on the period from arraignment to disposition or trial delays in general?
I don't have it with me, but I do believe we have county-by-county data on time from arraignment to disposition.
County by county, also related to charge level, felony A and B misdemeanors, so to sort of track the ready roll statute?
I'd have to check and see how far it's broken down, but I can certainly find out and get back to you on that.
Great, and then sort of taking off the data hat and putting on the policy hat, what do you think DCJS can do to help solve this crisis?
Yeah, I think that it's mainly an issue within OCA. You know, our role, you know, we provide support, provide funding to prosecutors. We provide a very small amount of aid to defense. It's mainly the Office of Indigent Legal Services that does that. You know, so I think our role is minor. I do agree with you that it's a very important issue. You know, when we talk about things like, you know, the number of people being held in jails, you know, one part of it is who's going to jail, but another part of it is how long are they in jail, and certainly on the pretrial side, it's a huge issue. So, you know, I'd be happy to follow up on the data piece and certainly be willing to work with you, OCA, and anyone else on what I think is a very important isslong
Great, thank you very much. We'd really like to see trends, especially, and you know, it's something that in the 5 boroughs of New York City know a lot about. We heard about it from Long Island perspective as well. Speaking of reporting, the governor proposes the sort of expanded reporting for summonses, et cetera. Similar to last year's proposal, as I understand it. Is that fair to say?
Yes, basically, right now, we get fingerprintable offenses, and we can do all kinds of reports or data with regard to fingerprintable offenses. This would give us information with regard to non-fingerprintable offenses.
Great. And last year we covered that it would be sort of part of a unified database with the fingerprintable offenses, so there'd be ways to sort of cut it to include fingerprintable and non-fingerprintable offenses in terms of how it was sort of stored and analyzed.
Yeah, I don't want to say unified. I don't know in terms of the logistics. I don't think they would be combined, but certainly our intention would be to be able to provide the same level of data with regard to those offenses that we provide you now with regard to the fingerprintable ones.
Great. And Assemblymember Lenthal and I carry a bill that would do this. Let me just kind of speed round here for a second. Which of these factors either would be authorized or required to be included in the information? Obviously, offenses and violations are included, right?
Yes, like harassment, disorder.
Demographics on individuals charged, race, ethnicity, et cetera.
Yes.
Whether the summons or appearance ticket contained a custodial arrest or not?
I don't know if the proposal is that specific, and I'd have to check, but there may be language in there that indicates that it is subject to regulation by the Commissioner of DCJS in terms of how it gets reported.
Disposition?
No, I don't believe it's disposition because it's coming, the requirement is for the police department, so I don't believe they would have the disposition information.
And therefore not sentence either, right? Neither disposition nor sentence.
Yeah, no, that would have to be information that would come from OCA.
Great. And then, of course, that could be aggregated countywide, statewide, any common, regionally, et cetera.
Absolutely.
Great. That's important, and hopefully this year we can get that over the top, since knowing what we're talking, you've said fact-based a number of times. I couldn't agree more. Speaking of which, let's talk about the Arnold Foundation briefly that you referenced earlier. How do you ensure that sort of the algorithm that goes into the predictive score that the Arnold Foundation throws out is sufficiently transparent? sure, it's showing preliminarily to do a better job of having fewer people held on bail and arguably or potentially lowering violent crimes or violent actions among those who are out in that period. But for each individual case, how do we know that there's a relationship between what that individual has actually done in the past and the likelihood that they'll be given the capacity to get out on bail?
I guess 2 points I'd make. First, I indicated that we believe that this should be given to judges as a tool. I don't think you can ever replace the judgment of a judge with a tool, but I think the more tools you can give a judge to help them exercise that discretion. So, you know, there may be a case where the risk instrument says one thing, but a judge, you know, given his or her experience, says, I can safely release this person regardless of what, because there's some factor that didn't get put in here. Secondly, as to the algorithm, yeah, we in other settings have taken algorithms that have been developed, used our research staff and our DCJS data, and improved on them to make them New York specific, to be as tailored as they can to, you know, our particular circumstances here in New York. And I certainly would anticipate that we do that. And I think it's got to be a very transparent process. I think that in creating that, you know, we need to make sure everyone understands what we're doing. And then the last thing I would say is, I mentioned training. You can't just put an instrument out, throw it out there and say use it. I think it's important, if you're going to do this and do it right and expect to get the results that we truly do lower jail populations and increase public safety, everyone needs to be trained. So the judges, the lawyers on both sides using this know what the algorithm is, know how we came up with it, know what it means, you know how to use it. And I think if you do all those things, the evidence shows that you do get to a point where you can drive down jail population and at the same time make the state safer.
I would strongly urge that anytime we're talking about these, whether as part of a change in the methodologies proposed by the governor or not, that we are a lot more careful about telling the judges and requiring the judges consider what it really means, what the underlying factors are that go into that risk assessment, not just, you know, it's very appealing to simplify everything and every human being to a score. That actually is not how the criminal justice system works. It's the reason we have the criminal justice system we have. And to implement a score absent a whole lot of requirement for due diligence and understanding by the judge be extra constitutional, among other problems.
I couldn't agree with you more.
Briefly, actually, just final issue on transparency. We did talk about body cams before briefly. Does DCJS have an opinion or a willingness to be part of the solution on how we make body cam footage available to the public while still protecting individual privacy rights?
We certainly have spent time with the issue of body cameras. Specifically, the issue was considered by the Municipal Police Training Council. We're the staff arm for that council. We did a lot of research over the period of about a year. The council recently adopted a model policy with regard to the use of body cameras, which does touch on some of those issues, but certainly I don't think is the end of the discussion. But yes, you know, I think body cameras clearly have a place, and I think that there are a lot of issues that go along with them that are very important issues that need to be hashed out, so we'd be happy to be involved.
Look, they have the potential to really help both law enforcement and civilians who are interacting with law enforcement. Frankly, I would like to see some funding in here to help us devise a system and a storage capacity for how that becomes public and when it becomes public. Because absent that, the truth is that's going to hold up any kind of expansion of body cameras, which I think there's increasingly a consensus is something we need to do. We're not going to be able to do it without funding sort of the back-end data question. That's not an additional question when it comes to this new technology. It's a core question about whether the technology can move forward.
That's the cost. The cost of the cameras up front is almost
Exactly
non-existent
right.
compared to the data storage and management costs.
And management being the key word there, even more than storage probably if the curve continues on storage.
Yeah, if you never need it, it's easy to store.
Finally, the special counsel was proposed. I asked a question last year. There was a little ambiguity on it. It's been a year. The special counsel proposal seems similar to last year's, so maybe there's more clarity this year. Governor appoints a special counsel to consider whether to recommend an independent prosecutor is appointed. That special counsel has the capacity to access the grand jury, findings and transcripts, all of the information related to the grand jury proceeding. Is the special counsel able to share that information with the executive or not? And if not, is the special counsel able to make a recommendation other than yay or nay to justify or explain why the recommendation is what it is?
The way I read and understand the proposal, the special counsel would have the ability to share as much information as necessary in the context of making a recommendation to the governor. I don't believe that a reasonable reading of this bill or reasonable interpretation would say that the special counsel is limited to walking into the governor's office and saying yes or no, and I can't answer any other questions.
And would the governor be allowed to share that information in announcing to the public his or her decision, or would the governor be under the same limitations on sharing information that emanates from a grand jury proceeding as everyone else is?
I don't read the bill in a way that would allow for additional disclosure of that information beyond from the special counsel to the governor.
So doesn't that take the black box of the grand jury room, extend it into the executive, and then stop it right there so that from the perspective of the public and policymakers and law enforcement in general, they're left with the same black box, just one where a different branch of government has also the ability to come out and tell us no more than we've heard before, which is just yes or no?
If that were the end of the day, you know, you could make that argument, I think. But first of all, you're balancing or trying to balance some very important policy considerations here, and grand jury secrecy is one. And secondly, if the governor, following a recommendation from the special counsel, appoints a special prosecutor, you know, I would argue that it's not the governor's position at that point to be making public statements about the case before the special prosecutor has a chance to do his or her work. I think that the appropriate course of action at that time would be not to disclose anything further until the special prosecutors had an opportunity to do their job.
Look, it's those two competing conclusions that lead to such concerns about this. You're probably right about that, but what does that say about the overall proposal? I think it's something that we still need to really consider. Thank you.